What's up, guys? Brian Fellow Law Group PLLC with your Florida Law Weekly case update. Happy Friday. Hope everybody's had a great week. And if not, hey, at least it's over. So we got the weekend coming up. I got 3 cases for you. They're all kind of different. They're not all family law cases. Only one is family law, but they're all interesting in their own way. So the first case is interesting because not because of the case itself, but because of who is bringing the case. This is Alexander versus Donald J. Trump. This is our president, President Trump. And actually, it's Trump was the one that brought the lawsuit. So it's Trump suing essentially the members of the board of the Pulitzer Prize. You know, the Pulitzer Prize that people get awarded for writing. So basically, the Pulitzer Prize back in, I believe, 2017 or something like that, gave a Pulitzer Prize to 2 articles issued in the Washington Post and the New York Times had to do with the alleged Russian interference that Donald Trump basically was allegedly involved in the 2016 election. Russian interference, everybody remembers all that. And so basically, Trump said to the Pulitzer Prize board, hey, what are you guys talking about? This is all BS. You guys got to, remand this or basically revise your Pulitzer Prize, take it away. They don't deserve it, all that stuff. They refused to do that, and actually what they did was they issued a sort of a statement online on their website that said, hey, we hired 2 different independent investigators to look into these articles, and they didn't find anything that needs to be corrected. The facts are the facts. They are what they are. Didn't correct it. So Trump sues them, and he sues them in Florida. And so what this case actually technically has to do with his personal jurisdiction. So the defendants, which are members of the board of the Pulitzer Prize, some of them were saying, hey, Florida court, you lack personal jurisdiction over me because, I don't have anything to do with Florida. And so the appellate court actually said, well, there's enough facts here to have personal jurisdiction over these people. Basically, the Trump alleged defamation and conspiracy, and when it's a conspiracy, you can sort of group everybody together. And so there were connections to Florida here in that one of the members, I think, attended a meeting regarding the issue while they were in Florida, and one of the people that actually, like, I guess, issued a complaint did so while they were in Florida, complained with regard to the that the statement needed to be corrected, something along those lines. But basically, there's 2 connections, minor connections to Florida, but that was enough to confer personal jurisdiction over the defendants here in Florida. So that was interesting because Trump, President Trump. The next case is the family law case that we have this week. It's Kiswani versus Hafza. And I thought this was interesting because this is time sharing and a parenting plan. And this sort of goes back to the whole thing when a few years ago, it was always the case law was such that if you're going to deny a parent time sharing of some sort, you had to give them steps. They called it concrete steps to regain time sharing with their child. Now that has sort of been reversed, and now they've kind of gone in the opposite direction. So what this case says is, so they didn't have actually a set time sharing schedule for the mom. She must have had some sort of issues, who knows. But the parenting plan said that if the mom does certain things, then based on the recommendations of the child's therapist and some medical doctors and things like that, then the time sharing would essentially be modified, I guess, and then she would gain time sharing. So this was incorrect for a number of reasons. Number one, you got to have at least some sort of time sharing plan in there. You can't just leave it up in the air and say, oh, we don't know. We'll determine the time sharing later based on the recommendations of the professionals. So that was number one. You can't do that. Number two, you can't delegate to third parties the conditions of the time sharing, like when she would be able to talk to her children, what time sharing she would actually have. You can't do that. Nope, not allowed. You can't delegate to third parties. And then in the same sense, you can't delegate to third parties to say, when her time sharing would begin. Like if she completed certain things. Nope, not good enough because you're leaving it in the hands of a third party to make those determinations. You can't do that. And then the last thing, which was sort of, this is like the reverse of the concrete steps, is you really, according to this case, you really can't even like in advance say if the mom does these certain things, then she gets the time sharing, because 6113, there's only certain ways to modify the time sharing. So basically, what I'm taking away from this is you have to have a certain time sharing plan in place. And then you can't say that, well, it'll be modified if certain things happen in the future. No, the only way to really modify it is to file a supplemental petition to modify. So you guys got to be super careful with these kind of things, because we love to do these things. We love to sort of like pass the buck, say, hey, therapist, you decide when this parent gets time sharing. You decide what the conditions of the time sharing will be. You decide what the actual days and time sharing, the plan, the schedule will be. No, you can't do that. You can't delegate to third parties. So be careful with that. Last case is I thought this is kind of funny. Not. I mean, it's too bad for the litigant, but not really funny. But it's an interesting thing, and it's really got to be super careful as you practice in civil court as a proposal for settlements. Neeld versus Combs, and to me, it looks like it's a proposal for settlement. They put in $100,000 as the proposed settlement, and then as the plaintiff says, okay, I offer to settle for $100,000. And then on the 29th day, the defendant says, yep, this is the insurance company, says, yes, I accept $100,000. But it was a mistake. It was supposed to be $1 million because that was the policy limits. They didn't, it wasn't supposed to be 100,000. They left out those extra 3 zeros. And so for whatever reason, the plaintiff waited until like 4 or 5 months later and filed a motion to try to set aside that settlement. And the appellate court said, hey, too bad, too sad. Like, you're just out of luck, because it was a legitimate proposal for settlement that plaintiff filed. Defendant accepted it by filing their acceptance. And, it was a mistake. That's too bad. They took too long, and it's statutory, so there's really not a lot of wiggle room. So you got to be very, very, very careful. If you file a proposal for settlement, you can withdraw it during that 30 days before the defendant accepts. But if you wait and the defendant accepts, I mean, you're pretty much out of luck. So got to be super careful. So too bad for that litigant, because they may have gotten messed out of $900,000. All right, guys, have a wonderful weekend. Take care. Have fun with everything.